What's up, everybody? It's Stephen A. Williams, president and founder of the creditrepairshop.com. And in today's video, we're going to talk about debt collection practices. We're going to talk about the issues that people are either writing about in my YouTube comments or from news reports that I've seen dealing with debt collectors, some of the practices, the illegal practices, or the violations that they're continuing to make. And I believe that it all boggles down to people not understanding their rights. If you can think about if you are one of the unfortunate ones that have a debt collector come after you, one of the first things that people will do, and I'll admit I did this when I was uh, younger and learning about having to deal with debt, is that the first thing is people don't answer their phone. Or I remember in some of the people my age might remember this, is where you would have one of your children answer the phone. I remember as a kid, check this out. I remember as a kid, there used to be the insurance man would come around, and what they would do, I don't even remember what type of insurance. Maybe it was homeowners insurance, but they used to send people door to door to take payments. And I remember the insurance man going through our neighborhood. I guess most had multiple customers, but I remember a few times where my parents would say that to tell them that they wasn't there. I mean, my parents may not think I remember. I think I was probably 7 or 8 years old, but I do remember that. Why does stuff that with emotions tend to stick in our mind? And I just made a video short about that. That debt collectors, their number one thing that they try to do is get you emotional, because when it gets you emotional, it makes it hard to sleep. It makes arguments with your spouse. All types of issues come about until you resolve it. But yeah, I remember my parents saying, "Tell them that we're not here." And then when they would call on the phone, you probably heard stories where kid would answer and they just say, "My mom or dad isn't here." And so that's one of the things that a lot of people have probably went through. It's kind of funny after it's all done, but you know, I just by looking at this, and it brought up some old memories. So, so the big thing that you got to keep in mind is that you can't avoid it. The best way to deal with a debt collector is to, number one, confront that debt collector, make them prove everything. But even with that being said, let me just run through some of the stuff that we see in the news, some of the stuff that I've seen dealing with clients, some of the stuff that people have wrote on YouTube about what debt collectors are actually doing to them, other than trying to get them emotional. Is that debt collectors, and I mainly see this with the smaller companies, is that some of them are not even registered to even do debt collection in the state that they're trying to collect from. So one of the things that you should do is you should look at, in my state of Wisconsin, it's called the Department of Financial Institution. And this is where debt collectors must be registered. You can search online on Google debt collection or debt collectors registered for, and put your state in there, and you will see probably a website that your state has where the debt collector has to be registered. Now, there are some states that don't require it to be registered, a debt collector to be registered. They just require that they are a business, that they have proof that they are a business, that they just can't be an individual going out there trying to collect debt on people. So you want to make sure that they are registered to collect debt in your state, because that could be one of the ways that you can make that debt just go away, because that's a violation of your state laws. Now, there are overarching federal laws, but for this one, for debt collection companies to collect in your state, if you have a law in your state that they must be registered, the federal law will not supersede the state law. Most of the time, it will be, but it will go the other direction, where the federal would supersede the state. but states do have the right to require debt collectors to register to collect debt in their state. Another thing that you can look at doing, which is probably one of the lesser known uh, issues when it comes to debt collection, is to see if, like, say, if you have a debt collection coming from the original creditor, if the debt has been charged off and the original creditor is coming after you, and this would be for a state, a company in your state, not necessarily a national company. They are not, and this again goes to my state of Wisconsin, and and this is just giving you more information so you can check the laws in your state, is that original creditors, companies, cannot collect debt for themselves. Like they, once they charge it off, they cannot be a debt collector. Even though they could have another company and set it up to be a debt collector, in my state of Wisconsin, a original creditor cannot be in the debt collection practice. So now, what would distinguish being in debt collection and being the original creditor trying to collect on the debt that's owed to you? For the state, for my state, they would have to hire someone to go do it for them. That's why they'll have attorneys collecting the debt or company collecting the debt. They cannot be the debt collector themselves. So once they charge off that debt in our state, they have to hire someone. And actually, in my state, I've seen that actually uh, been utilized even by companies that are national companies, that they will not try to collect the debt in our state. They will use a third party collection agency just to remain compliant. Another thing, which is a this is like one of those gray areas, is that if a debt collector makes a threat to sue you and they don't go through with the lawsuit, a lot of people don't know that that is a violation of the Fair Debt Collection Practices Act. And but it's a gray area because it's like, okay, we threatened we're going to sue you, so when does the clock start ticking? Uh, we can threaten to sue you, and then once we get our ducks in a row, we can come and sue you. Or so it's a gray area, and it is not uh, specifically with a time frame in the Fair Debt Collection Practices Act. But what I've been able to gather from dealing with my own clients, dealing with debt collection companies who have made the threat, is that they're going to mainly do it within 30 to 45 days of making a threat. If they do not sue you within that 30 to 45 days of making that threat, they're more than likely not going to sue you. They're just going to pursue you by using normal debt collection practices, by making calls, which they can do every 7 days, and sending you letters in the mail. The next one that I see a lot of is that the debt collection representatives will sometimes pretend to be like a legal professional, like they're kind of pointing you in a direction, giving you legal advice on what you should do for the debt. And even though that they're recording the conversations, uh, the job of the debt collection representative, which number one wants to get you emotional, and number two, to try to collect that debt. So let me give you an example of what would be, in a way, legal, like in a way giving, acting as if they're a legal professional. So if they were to say it in these words, hey, you owe this debt, and if you don't pay this debt, you're going to end up getting garnished. You're going to end up, you're going to end up getting a judgment. You're going to end up getting garnished of your wages, or your bank account money is going to be taken out of your bank account. So, and this is another one of those gray areas, but this comes from me being experienced from dealing with my clients, from dealing with people who write comments here on YouTube, and from, reading the news reports. By them making those directions, that is in a way acting as a legal professional. They're not allowed to say those things, because what they're doing is they're like tilting the scales from you being able to initiate your rights, because all they're focused on is telling you what's going to happen if you don't do this. Now, if you're on the outside with someone like a third party, you're speaking to one of my representatives with my company. And again, we can't give you legal advice, but we can tell you what you can and cannot do. But it would, either which way, the information that we would give you, and we give you both sides of the information. It wouldn't be one-sided where we were saying this is going to happen, this is going to happen, this is going to happen. We would say this could happen, and also you have a right to fight, and this is the way that you would fight against that debt collection lawsuit. Uh, so that it's like one of those gray areas, and you just have to kind of pay attention. That's why they get you emotional, because if they get you emotional, you don't remember everything about the conversation, and you might even get to start saying things that you would not want to be played if it was in court from a recording. The next thing is making false claims that you're already being sued. This is one of the things that I get a lot of YouTube comments on and emails, where people think that they're already being sued. A debt collection company said, hey, we are trying to sue you, we're trying to track you down, you're already being sued. You would know if you're being sued, and let me tell you a few ways. There's a third party way that you'll know that you're being sued, which is crazy, because you know that your information is not supposed to be shared to a third party. But you probably, if you have a debt collection lawsuit, have gotten a letter from a third party attorney saying that you are being sued and that they're offering their services to deal with that lawsuit. So you're like wondering, how is that even happening? And it's because they put you on it's a public notice once you get sued. So if you receive something like that, yes, you are getting sued. Don't disregard that just because it's an advertisement. Don't disregard that, because they are getting information directly from the court. Now, but a debt collection uh, uh, representative cannot call you and just make claims saying that you are being sued and that the legal process is working its way through all of that stuff. No, what they have to do is take they have to do that suit, and then you will get the paperwork either by service to you, or you will be notified by the court in some manner that you are being sued, which is going to be by service. But if they attempt service and you're not there, they can do a legal notice in your newspaper. And once that legal notice is put in there, I think in my state, you have to do it a couple of times. They have to run it a few times. Once that's done, they can take that right to the judge and say, hey, we tried to serve them, unable to serve them, but we have proof of service. In some states, they're not allowing them to get away with that, but in a lot of states, they are. Um, Next thing is time barred debt. We just did a summons response, and the individual submitted the documentation to me showing that the debt that he is being sued for is past the legal statute of limitations. It was for Virginia, 5-year statute of limitations. Now, uh, a lot of times when people are getting sued, they get confused about how the statute of limitations works, or the time barred period works, which is a different word for saying statute of limitations. It starts from the charge off date. So if the charge off date, you got to go by the month and the day. So if it crosses, for this example, 5 years and one day past that time frame, they cannot legally take you to court and sue for that. There's no legal option. There's a moral, they can try to get you to pay it on a moral obligation, and a lot of people uh, would say, okay, I have a moral obligation to pay it, or let's do a settlement. But there's no legal. They cannot take you to court to make you pay that debt. But the courts are not going to tell you that it's past the legal statute of limitations to collect. As a matter of fact, they're not even supposed to bring cases to the court that are time barred / past legal statute of limitations to collect. So that's why the judges are not even like alerted towards it because they're not even looking for it. Like, why would a debt collector do something like this? Well, we just had someone that uh, just brought us and we did the response, and it they're going to automatically win. It's going to get dismissed because it's past the time bar period to even bring that suit. And as a matter of fact, it was past the time bar period. It was August, by 2.5 months. 2.5 months. All right, let's see. Validation notice as required by federal law. I get a lot of questions on this one. Sent debt validation and got some statements back, or even sent the debt validation and didn't get nothing back from the debt collector. Let me take on both of those. First, let's just talk about the debt validation that you sent to a debt collector and they sent some statements back. They're doing what's the bottom line requirement by federal law. That's what they're doing. Uh, According to the Fair Debt Collection Practices Act, all they have to do is send you a couple of statements and show how the who they got the debt from and the last reported balance. That's it. But you have to do your job on challenging everything about that debt, or they're just going to be able to get away with it. Another thing that has happened is that with the Supreme Court ruling in 2017, when a debt collection company who bought the debt and they only collect debt for themselves, let me be clear, because this could be so confusing. It was to me, and I had to read that court decision many times over. If a debt collection company buys debt and they only collect the debt that they buy, they don't go and do third party collections. According to the Supreme Court ruling in 2017, they do not have to do a debt validation for that debt in the sense of the Fair Debt Collection Practices Act. They just do not. And you don't have to take my word for it. Look up Justice Gorsuch, uh, 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 what do you call it? Where the prevailing side. He wrote the whatever they call it for the prevailing side. And he stated in there that if they're not collecting debt for quote others and they're only buying debt to collect for themselves, they assume the position of the original creditor. So when that decision came down, debt collectors can literally get a validation from you or from my company, from anyone, and they can throw that in the trash after looking at it. That's why it has to be done the right way. So what you're doing is you're making them prove the claim. See, that's one thing that was not like they don't want you to focus on that at all. But when I say claim, that's the dollar amount. That's the specific dollar amount. There is no one, Supreme Court, state, federal, whoever, that is going to allow a law where someone could just bring you a bill and they don't prove how that bill was accumulated. There's no law for that. So even if a third party debt collector assumes the position of being the original creditor because of that Supreme Court ruling, they still, even in that ruling, states that they have a responsibility to prove that amount. But what makes it hard and difficult is that really it does not get to that point until it goes to court. There could be a lot of back and forth before that to where you're going to have to request so much documentation to get them to act, because at first they're not going to act in most of the time. They're just going to read it, and if it doesn't have specific wording that's going to make them wake up and say we need to get this information to this individual, they're just going to throw it away. We specialize in doing that, and I'm going to give you a letter that can wake them up at the end of this video. So uh, if if you have a debt that is purchased by the debt collector and they do not collect for other collect for others, that's how it's stated, for others. Others mean for other companies that they only buy debt and collect for themselves. They will not have to be under the Fair Debt Collection Practices Act, but they still have to verify how they got that claimed amount. And it still does not hurt to make them prove that information. If they don't provide it to you, that's just helping build your case in court. Because in court, when they take you to court, they will have to show the paper trail of all of that, because that's the conformity. So the Supreme Court decision did not say that they don't have to show conformity. They don't have to show that paper trail. They still have to show it, but it's just at the time that they have to show it. Some of the time they might go ahead and send everything to you, but most of the time they're not going to want to even deal with that until they decide to take you to court, and then they send you a court summons. But you'll already be a step ahead, because you would have had proof that you've been requesting this information, so you would be able to make an educated decision on how you would be able to move forward on that debt. All right, so if you have any questions, please post them in the comment section. Please like this video. Please share this video. If you have not subscribed to the channel, please subscribe. If you need help with your credit, please visit us at thecreditrepairshop.com. Watch the video, what makes us different, so you can see my 8-point validation process, my 2-phase settlement process. If you need your credit reports and scores, go to the website your3scores.com to grab your TransUnion, Equifax, Experian credit reports and all 3 scores. If you have debt collectors coming after you, grab my 3-pack of letters: statute of limitations, debt validation, and cease and desist collection activities letter. I do ask for a donation on those, but those can save you time, money, and frustration. And the instructions are on top of those letters, so you know which one to use depending on your specific situation. Thank you for your time. This is Stephen A. Williams, President and founder of thecreditrepairshop.com.